Hi everyone, Gigi Santoro, Santoro & Sons Real Estate Group, and today I have such a treat for us. I have Rob Cohen from Cohen Law, 18 years worth of Cohen Law experience, and I want to go over some basic things that you will see when you get into escrow as a buyer. You're going to get a document from escrow that asks you a bunch of very complicated questions on how to take title to a property, and I have great resources here for us to talk about what you should check off and how you should do it. So Rob, let's talk a little bit about how would somebody look at all of these questions and try to figure out the best thing for them if they are a married couple. I'm going to ask you three questions. So married couple first, what would be the best and most advantageous way to take title?
Okay, so assuming that the married couple is taking the property as community property, then the most advantageous would be for the two of them to take title as community property, and the key words would be to include with right of survivorship. The reason why right of survivorship is so important is because it provides a mechanism that if one of the spouses passes away, the other spouse automatically receives all of the real property without any type of formal probate administration or court involvement. That right of survivorship language means that as soon as the spouse passes away, the other spouse automatically receives that spouse's portion. As opposed to if it was simply taken title as community property, it would require a court petition to have the deceased spouse's community property interest transferred to the surviving spouse. So right of survivorship is very, very important when taking title in community properties.
It says the first item, you have a choice of 4 or 5 different options on this form. It says just as joint tenants.
Right.
So you wouldn't, why would you not, why would that even be on there then if it has the third item down is right of survivorship?
So joint tenants is typically not the best way for a husband and wife to take property.
Almost everyone does.
And so let's understand there's a distinction here. The way you take title has legal ramifications both in the family law context and in the probate context if there is a passing.
Okay.
With respect to the family law context, even if a husband and wife take property as joint tenancy, should they divorce, the property is treated as if it was held as community property. So there's no real distinction. With respect to if one of the spouses passes away, the joint tenancy provides the exact same right of survivorship that a community property with right of survivorship holding would provide. So it really doesn't make any distinction or difference.
Okay.
But typically you wouldn't see husbands and wives take title as joint tenants unless they're not intending for the real property to be community property and they're intending for it to be outside of some sort of an estate plan. You would see husbands and wives taking title as joint tenants if, let's say, it was a second marriage and either the husband or the wife already had an estate plan, they already provided for their children or for other heirs, but they want this real property to be taken out of that estate context and not be part of a community property claim that the surviving spouse would have. So they might take title as joint tenants in that context.
Okay.
But if it's a first marriage or the intention is that it's a community property asset, take it as community property with right of survivorship.
Okay. Then there's tenants in common. So how would that be a different thing between?
So tenants in common basically says that however many tenants there are have a complete and severable right to that percentage interest in the property. So if they were taking title but they weren't going to acquire the property in equal provisions. Let's say it wasn't a 50-50.
Okay.
Let's say it was 75-25. Then you could have a tenancy in common which would have 75% to one co-tenant and 25% to the other. You would have to be really careful how you structure a tenancy in common arrangement because, again, if it's an asset that's acquired during marriage, it would be presumed to be community property unless there was some other arrangements made. So before a husband and wife take property as tenants in common, they really need to communicate with a family law attorney to ensure that they're intending for this asset to not be community property and that both co-tenants understand that. In a tenancy in common situation, each of the co-tenants has the right to sell, encumber, transfer, or devise through a will or trust their own interest in the property, and the other co-tenant has no rights to it. But
without permission, they can
Correct.
just do it on their own.
Correct, because they have an inseverable right to that interest that is theirs.
Right.
And the other co-tenant doesn't have an argument or a basis to object to it because each co-tenant owns their piece to the exclusion of anybody else.
Right. Wow. Okay. So, okay, so I think that was fantastic help to us because I just learned something. My clients ask me all the time about what to pick, and I always say as joint tenants, but I did not know to say community property with the right of survivorship. In fact, I don't even think I did that, so now I need to go back and regroup. So we love having guys like this out, like Rob, and I want you to look down here because this is his contact information and he will be available to answer any of your questions going forward, okay? Thanks so much for joining us today, and we look forward to working with you, and we want to make sure you get the best deal, so make sure you call Gigi Santoro, Santoro & Sons Real Estate Group. Have a great week.